I was sitting in my home office on a Thursday afternoon when I heard the doorbell ring, and I knew from the aggressive way the person was pressing it 3 times in rapid succession that this was not going to be pleasant. Living in Pleasant View Estates in suburban Phoenix, Arizona, I had become accustomed to unexpected visits, but nothing could have prepared me for what was about to unfold over the next several months. My name is Jamison, and I am a telecommunications engineer who works remotely for a major cellular network provider. I had moved into this planned community 6 months earlier, attracted by the reasonable housing prices and the promise of a quiet neighborhood. What I did not anticipate was that the homeowners association would become the bane of my existence. I walked downstairs and opened the door to find a woman in her late 40s standing on my porch, clutching a clipboard like it was a holy relic. She had that distinctive haircut, the one that screamed entitlement from a mile away, perfectly highlighted blonde hair styled in what people online called the speak to the manager cut. Her name tag read Barbara Hendricks, HOA president. Mr. Jamison, I presume, she said, not waiting for my response before continuing. I am Barbara Hendricks, president of the Pleasant View Estates Homeowners Association. We need to discuss a serious violation you have committed. I leaned against the door frame, already feeling exhausted. What violation would that be? She pointed upward with one manicured finger. That monstrosity you installed on your roof, the cell phone tower equipment. It is unsightly, it violates our community aesthetics guidelines, and you did not get approval from the Architectural Review Committee before installation. I followed her gaze to my roof, where I had indeed installed a cellular signal booster system about 3 weeks earlier. The equipment consisted of an external antenna mounted to capture the weak cellular signal from the nearest tower, which was unfortunately located nearly 8 miles away due to the layout of our area, and an amplifier unit that boosted the signal throughout my house. That is not a cell phone tower, I explained patiently. It is a legally licensed signal booster system. I need it because the cell reception in this neighborhood is terrible, and I work from home conducting network diagnostics for my company. Without reliable cellular connectivity, I cannot do my job. Barbara's face turned a shade of red that reminded me of an overripe tomato. I do not care what it is or what you use it for. It is visible from the street, it ruins the uniform appearance of our neighborhood, and you will remove it within 7 days or face fines. Actually, I do not have to remove it, I said, keeping my voice level. I have an FCC license for this equipment, and federal law preempts local regulations when it comes to licensed telecommunications equipment. She laughed, a harsh sound that had no humor in it. Federal law, please. This is a private community with binding covenants. You signed those covenants when you purchased your home, which means you agreed to follow our rules. The antenna comes down, or you will pay $500 per day until it does. I felt my jaw tighten. I think you need to consult with your HOA attorney before you make threats like that. The Telecommunications Act of 1996, along with FCC regulations, specifically protects licensed amateur radio operators and licensed signal booster installations from exactly this kind of interference. 7 days, Mr. Jamison, she repeated, making a note on her clipboard. The first fine will be assessed on the 8th day. Have a good afternoon. She turned on her heel and walked back down my driveway to her white Lexus SUV, which she had parked in a way that blocked half of my mailbox. I watched her drive away, then closed the door and immediately went back to my office to start researching my legal position more thoroughly. I had been telling the truth about the FCC license. When I installed the signal booster, I had gone through the proper channels, and obtained a license from the Federal Communications Commission for a consumer signal booster system. The license was legitimate, registered to my address, and authorized me to operate the equipment on specific frequency bands used by my cellular carrier. The system was also registered with my carrier, as required by federal regulations. I pulled up the FCC documentation on my computer and began reading through the relevant sections of the Communications Act and the Code of Federal Regulations. Title 47 of the CFR, specifically Part 20, dealt with commercial mobile radio services and included provisions about signal boosters. More importantly, Section 332 of the Communications Act included language about state and local governments not being able to regulate the placement of personal wireless service facilities in ways that prohibited or had the effect of prohibiting service. The legal question was whether an HOA counted as a local government for purposes of this preemption. From my research, I found several court cases that had addressed this exact issue, with mixed results depending on the circuit and the specific circumstances. However, the FCC had issued rulings clarifying that licensed equipment, particularly amateur radio installations and licensed signal boosters, received stronger protection than unlicensed devices. I spent the next several hours compiling documentation. My FCC license, the technical specifications of my equipment, photographs showing that the installation was professionally done and minimally visible from the street, and copies of the relevant federal regulations. I also drafted a formal letter to the HOA explaining my legal position and citing the specific statutes and FCC rulings that supported my right to maintain the equipment. The following morning, I printed out my letter along with all the supporting documentation and sent it via certified mail to the HOA management office. I kept copies of everything for my records and made a note of the tracking number. I figured this would be the end of it once they consulted with a competent attorney. They would realize they could not enforce their demand, and we would all move on with our lives. I was incredibly wrong. Exactly 7 days after Barbara's visit, I received a formal notice from the HOA in my mailbox. The letter, printed on official Pleasant View Estates letterhead, informed me that I was in violation of Section 4.7 of the Community Covenants regarding external modifications and installations, and that I had failed to comply with the order to remove the offending equipment. As promised, I was being assessed a fine of $500 per day, starting immediately until the violation was corrected. The letter also informed me that if the fines exceeded $5,000, the HOA had the right to place a lien on my property and potentially initiate foreclosure proceedings to collect the debt. I called the HOA management office immediately. A bored-sounding receptionist answered and transferred me to Barbara's voicemail after I explained why I was calling. I left a detailed message explaining that I had sent comprehensive documentation of my legal position, and that the fines they were assessing were not enforceable under federal law. No one called me back. 2 days later, I received another letter, this time informing me that my fine balance had grown to $1,500. I was officially furious. I had tried to handle this reasonably and professionally, but the HOA was clearly not interested in anything resembling reasonable discourse. I decided it was time to hire an attorney. I started calling law offices in Phoenix that specialized in telecommunications law and HOA disputes. The first 3 attorneys I spoke with were not interested in taking the case. They either did not have experience with FCC preemption issues, or they thought the case would be too difficult to win given the binding nature of HOA covenants. The fourth attorney I called was different. Her name was Margaret Ellis, and she had a small practice focused on telecommunications and technology law. When I explained my situation, she actually got excited. "This is exactly the kind of case that needs to be fought," she told me during our initial consultation in her downtown Phoenix office. HOAs have been overstepping their authority for years, and the FCC preemption doctrine is one of the strongest tools we have to push back against them. With your FCC license, you have a rock-solid legal position. Margaret was in her mid-30s, with dark hair pulled back in a practical ponytail, and an intensity in her eyes that told me she genuinely cared about this stuff. Her office was cluttered with law books and case files, and she had a whiteboard on one wall covered with diagrams and legal citations. "What is our first move?" I asked. "We send them a formal cease and desist letter from my office, making it crystal clear that their fines are illegal and that if they continue, we will file a federal lawsuit," she explained. "We cite the Communications Act, the relevant FCC rulings, and we include case law from circuits that have held in favor of FCC preemption over HOA covenants. We also demand that they rescind all fines immediately. And if they do not," she leaned back in her chair, "then we file suit in federal district court. The FCC has exclusive jurisdiction over licensed telecommunications equipment, which means we can argue that state contract law regarding HOA covenants is preempted by federal statute. We can also seek attorney fees under the Communications Act if we win, which means they will be paying for their own stubbornness." I hired her on the spot. Margaret's cease and desist letter went out the next day via certified mail and email. It was 6 pages of dense legal argument, supported by citations to federal statutes, FCC regulations, and case precedent. She laid out in excruciating detail exactly why the HOA's actions were illegal and what consequences they would face if they continued. I honestly thought this would be the end of it. No reasonable organization would continue down this path once they received a letter like that from an actual attorney. Once again, I had underestimated the stubbornness of the Pleasant View Estates HOA board. 3 days after Margaret sent her letter, I received a response from the HOA's attorney, a man named Gerald Whitmore who worked for a firm that specialized in representing homeowners associations. His letter was condescending and dismissive, arguing that FCC preemption did not apply to private contractual obligations, that I had willingly entered into the HOA covenants when I purchased my home, and that the Arizona courts had consistently upheld the enforceability of HOA rules. He also informed us that the fine total had now reached $3,000 and would continue to accrue daily. "They are bluffing," Margaret said when I forwarded her the email. "Everything in that letter is either wrong or deliberately misleading. The case law he cited is either distinguishable or has been superseded by more recent FCC rulings. He is hoping you will back down." "I am not backing down," I said firmly. "File the lawsuit." Margaret drafted the complaint over the next week. We filed in the United States District Court for the District of Arizona, naming the Pleasant View Estates Homeowners Association and Barbara Hendricks personally as defendants. The complaint alleged that the HOA's actions violated the Communications Act, were preempted by federal law, and constituted an unlawful restraint on my ability to use licensed telecommunications equipment. We also filed a motion for a preliminary injunction, asking the court to immediately stop the HOA from assessing fines while the case was pending. The legal process moved slowly, as it always does. We served the complaint on the HOA, and they had 30 days to respond. During that time, They continued to send me weekly letters updating my fine balance, which had now exceeded $5,000 according to their calculations. I ignored the letters, as Margaret advised, but I would be lying if I said I was not stressed about the situation. Even though I knew I was legally in the right, there was always the possibility that a judge might see things differently, or that some technicality might derail our case. The preliminary injunction hearing was scheduled for 6 weeks after we filed the complaint. Margaret and I spent hours preparing, going over the legal arguments and anticipating what the HOA's attorney might say in response. The hearing took place on a Wednesday morning in a federal courthouse in downtown Phoenix. The courtroom was smaller than I had expected, with wood paneling and a distinctly bureaucratic atmosphere. Judge Robert Morrison presided, a man in his early 60s with gray hair and a reputation for being thorough and fair. Margaret presented our argument first, walking the judge through the statutory framework of the Communications Act, the FCC's licensing requirements for signal boosters, and the preemption doctrine that prevented state and local regulations from interfering with licensed telecommunications equipment. Your Honor, this is a straightforward case of federal preemption, Margaret argued. My client has a valid FCC license for his signal booster system. The FCC has exclusive jurisdiction over the regulation of radio frequency devices. The HOA's attempt to force him to remove licensed equipment directly conflicts with federal policy and federal law, and therefore the HOA's rules are preempted. Gerald Whitmore, the HOA's attorney, stood up to present their counter-argument. He was a heavy-set man in an expensive suit, and he spoke with the kind of confidence that comes from winning most of his cases. Your Honor, this case is not about federal telecommunications law. It is about contract law and the enforcement of private covenants that Mr. Jamison voluntarily agreed to when he purchased his home. The HOA is not a government entity, and therefore the preemption doctrine does not apply. Mr. Jamison was free to choose not to purchase a home in Pleasant View Estates if he did not want to abide by the community rules. Having made that choice, he is now bound by those rules. Judge Morrison asked several pointed questions of both attorneys, focusing particularly on the distinction between government regulation and private contracts, and whether the FCC's licensing authority extended to overriding HOA covenants. Mr. Whitmore, has your client consulted with the FCC regarding their position on this matter? The judge asked. Whitmore seemed caught off guard. No, Your Honor, we did not think that was necessary. You did not think it was necessary to ask the federal agency that licensed the equipment in question whether local rules could override that license. The judge's tone was dry. Your Honor, the FCC does not have jurisdiction over private contractual relationships, Whitmore replied, but I could tell he was on his back foot now. Margaret jumped in. Your Honor, if I may, the FCC has issued multiple declaratory rulings on this exact issue. The FCC has consistently held that state and local restrictions, including private covenants, cannot prohibit or effectively prohibit the installation and use of licensed telecommunications equipment. I have submitted several of these rulings in our briefs. Judge Morrison nodded. I have read them, Miss Ellis. Mr. Whitmore, do you have any FCC rulings that support your position? We rely on state contract law, Your Honor, Whitmore said, which is preempted by federal law when there is a direct conflict, the judge said. I am prepared to rule on the preliminary injunction motion. Based on the arguments presented and the documentation submitted, I find that the plaintiff has demonstrated a likelihood of success on the merits of his claim. The FCC's licensing authority and the Communications Act's preemption provisions strongly suggest that the HOA cannot prohibit the installation of properly licensed telecommunications equipment. I felt a surge of relief so powerful that I almost laughed out loud. Therefore, I am granting the preliminary injunction, Judge Morrison continued. The Pleasant View Estates Homeowners Association is hereby enjoined from assessing further fines against Mr. Jamison for his cell signal booster installation, and from taking any action to compel its removal, pending the final resolution of this case. Furthermore, I am ordering the HOA to rescind all fines currently assessed. If the HOA ultimately prevails in this litigation, they can reassess the fines at that time, but given my preliminary assessment of the legal issues, I would not recommend that course of action. Margaret and I walked out of the courthouse into the bright Arizona sunshine, and I felt like I could breathe properly for the first time in weeks. "That went better than I expected," Margaret said with a genuine smile. Judge Morrison clearly understands the preemption issue, and he was not buying the HOA's contract law argument. "So what happens now?" I asked. "Now they have to decide whether to continue fighting or to settle. My guess is that Whitmore will advise them to drop it. They just lost the preliminary injunction, which is a strong indicator of how the final case will turn out. Plus, if they lose at trial, they will owe your attorney fees, and that could get expensive for them." I nodded, feeling a weight lift from my shoulders. "I hope you are right." We parted ways, and I drove home feeling victorious. When I pulled into my driveway, I looked up at my roof and saw my cell signal booster antenna, still exactly where it was supposed to be. Inside my house, my phone showed a full 5 bars of service. Everything was working perfectly. But my satisfaction was short-lived. 2 weeks after the preliminary injunction was granted, I came home from a grocery run to find something disturbing. My front yard had been spray painted with the words "Rule Breaker" in large orange letters across the grass. The paint was still wet, dripping into the soil. I immediately called the police and filed a report. The officer who responded was sympathetic but realistic about the chances of finding who did it. "Probably kids," he said, making notes on his pad. "Unless you have security cameras." "I do not," I admitted, "but I think I know who might be behind this. You think your HOA president did this?" The officer looked skeptical. "I think she might have encouraged someone else to do it," I said carefully. "We are in the middle of a federal lawsuit over a dispute about equipment on my roof." The officer nodded slowly. "Well, this is technically vandalism and trespassing. If you can get any evidence, camera footage from neighbors or anything like that, let us know. Otherwise, there is not much we can do." After he left, I spent 3 hours cleaning the spray paint off my grass, which mostly meant cutting the affected sections of lawn very short and hoping it would grow back normally. I also installed security cameras on the front and back of my house that same evening. I called Margaret and told her what had happened. She was furious. "This is witness intimidation and harassment," she said. "I am going to file a motion with the court to expand the injunction to include protection from retaliation." "Do you think Barbara actually did this herself?" I asked. "Probably not directly, but I would bet money she knows who did." These HOA boards can get cult-like sometimes, with board members thinking they are above the law and their supporters acting like enforcers. The expanded injunction was granted 3 days later, with Judge Morrison issuing a stern warning that any further harassment or retaliation would result in contempt charges and possible criminal referral. For about 2 weeks, things were quiet. I started to relax again, thinking that maybe the HOA had finally gotten the message. My grass was growing back, My cell booster was working perfectly, and I was able to focus on my actual job instead of legal battles. Then I got a call from Margaret that changed everything. "Connor, you need to sit down for this," she said, and I could hear the tension in her voice. "What happened?" "I got a call from an investigator with the FCC's Enforcement Bureau. Apparently, someone filed a complaint claiming that your signal booster is causing interference with other users and that your license was obtained fraudulently." I felt my stomach drop. That is completely false. My equipment is professionally installed, it is operating within the license parameters, and I have never had any interference complaints from anyone. I know, and the investigator seems to know that too. He told me confidentially that the complaint came from someone associated with your HOA, and that it appears to be retaliatory. But they still have to investigate it formally, because it is a complaint about licensed equipment. So what do I need to do? The investigator will contact you to schedule a site inspection of your equipment. Let him do his inspection, be completely cooperative, and provide any documentation he requests. He is going to verify that your equipment is legitimate and that the complaint is baseless, but we need to let the process play out. The FCC investigator, a man named David Chen, came to my house the following week. He was professional and thorough, spending about 2 hours examining my signal booster system, checking the technical specifications against my license, and using specialized equipment to measure the signals being transmitted and received. "Everything looks good here," he told me after finishing his inspection. "Your equipment is properly installed, operating within the authorized parameters, and I am not detecting any interference with other services. Whoever filed this complaint was either mistaken or lying." "I am pretty sure I know who filed it," I said, and I explained the ongoing litigation with the HOA. David nodded sympathetically. "Yeah, we see this sometimes. People think they can weaponize the FCC complaint process to get what they want. The good news is that this will actually help your legal case. I will be issuing a report clearing you of any violations, and you can submit that to the court." "Can you tell me who filed the complaint?" I asked. "Not officially, but I can tell you that it came from someone who identified themselves as representing the Pleasant View Estates HOA Board of Directors." After David left, I called Margaret and relayed what had happened. She was already drafting another motion, this time seeking sanctions against the HOA for filing a false report with a federal agency in an attempt to undermine our litigation. "This is getting serious," Margaret told me. "Filing a false report with the FCC can be a federal crime if it can be proven that it was done with malicious intent. I do not think we are at criminal referral level yet, but if they keep escalating, we might get there." The lawsuit moved slowly through the discovery process. We exchanged documents with the HOA's attorneys, took depositions of Barbara Hendricks and other board members, and built our case. The discovery process revealed some interesting facts that I had not known before. It turned out that I was not the first person in Pleasant View Estates to have a dispute with Barbara and her board. Over the previous 3 years, the HOA had initiated enforcement actions against 17 different homeowners for various alleged violations, ranging from having the wrong color mailbox to parking an RV in a driveway overnight. In 12 of those cases, the homeowners had eventually given in and paid fines rather than fight. In the other 5 cases, the homeowners had fought back, and the HOA had eventually dropped the enforcement actions when it became clear they would lose. Barbara's deposition was particularly enlightening. Margaret questioned her for nearly 4 hours, and Barbara's answers revealed someone who genuinely believed that the HOA rules were more important than federal law, property rights, or common sense. "Mr. Jamison's antenna is ugly," Barbara said at one point. "It ruins the aesthetic appeal of our community, and that affects everyone's property values. Have you conducted any study or obtained any evidence that his antenna actually affects property values?" Margaret asked. "I do not need a study. It is obvious. Is it equally obvious that forcing homeowners to have poor cell phone reception might also affect property values? That is different." "How is it different?" "Because cell phone reception is an individual problem, but ugly antennas affect the whole community." Margaret introduced into evidence the results of a signal strength survey she had commissioned. A telecommunications consultant had measured cell signal strength throughout Pleasant View Estates and found that the entire neighborhood had poor reception, with most homes getting 1 or 2 bars of service on average. My home, thanks to the signal booster, had excellent reception. "So poor cell phone reception is not just Mr. Jamison's individual problem, is it?" Margaret pressed. "It affects the entire community." Barbara had no good answer to that. We also deposed the other board members, and it became clear during those depositions that Barbara had not consulted with the full board before assessing fines against me, or before authorizing the HOA's attorney to fight the lawsuit. Several board members seemed uncomfortable with the situation and admitted that they did not fully understand the federal preemption issues involved. One board member, a man named Thomas Irving, was particularly candid. "I told Barbara that we should consult with an expert before pushing this issue," he said during his deposition. "I did not think it was wise to fight federal law, but Barbara insisted that the covenants were binding and that we had to enforce them uniformly." As the case progressed, I noticed something else happening. Other residents of Pleasant View Estates started approaching me, both in person and via email, expressing support for my position. Several of them mentioned that they also struggled with poor cell reception and had considered installing signal boosters, but were afraid of HOA retaliation. One neighbor, a woman named Patricia who lived 3 houses down, actually showed up at my door one evening with a petition she had started. "I have been collecting signatures," she told me, handing me a document with about 40 names on it. "This is a petition calling for the removal of Barbara Hendricks as HOA president and for the board to drop the lawsuit against you. A lot of people in this neighborhood are tired of her power trips." I was touched by the support but also concerned. "Patricia, I appreciate this, but I do not want you to get targeted by the HOA because you are supporting me." She laughed. "Connor, Barbara already hates me because I painted my front door teal instead of the approved beige. I am past caring what she thinks. Besides, enough people are fed up that she cannot go after all of us." The petition was presented at the next HOA board meeting, which I attended along with Margaret. The meeting was held in the community clubhouse, and the room was packed with residents, far more than usually attended these meetings. Barbara called the meeting to order and tried to proceed with the normal agenda, but she was immediately interrupted by several residents who wanted to discuss the lawsuit against me. "This is not on the agenda," Barbara said firmly. "Then we are adding it to the agenda," Patricia said, standing up. "We have a right to know how much this lawsuit is costing the HOA and whether the board really thinks this is a fight worth having." Barbara's face turned red. "The board acts in the best interests of the community. We do not need to justify our decisions to every homeowner who disagrees with us." "Actually, you do," another resident called out. "We pay the HOA fees that fund your legal battles. We have a right to know what you are doing with our money." The meeting devolved into chaos, with multiple residents demanding information and Barbara trying to maintain control. Finally, Gerald Whitmore, the HOA's attorney who was also attending the meeting, stood up and tried to calm things down. "Ladies and gentlemen, I understand your concerns. I can tell you that the board authorized a legal budget of up to $50,000 to pursue this matter, and we have spent approximately $30,000 so far." The room erupted. $50,000 to force me to take down a licensed antenna seemed excessive to many people, especially when the neighborhood had more pressing issues like deteriorating roads and a broken pool heater at the community center. "This is insane," one resident shouted. "We are spending 30 grand because Barbara thinks an antenna is ugly. It is about enforcing our covenants," Barbara insisted. "If we let one person violate the rules, then everyone will think they can do whatever they want." "His antenna is legal under federal law," someone else called out. The meeting ended with no resolution, but I could tell that Barbara's support on the board was eroding. Several board members looked uncomfortable, and Thomas Irving actually apologized to me privately after the meeting. "I am sorry this has gone so far," he said quietly. "I have been pushing for us to settle, but Barbara will not hear it. She thinks backing down would make her look weak." 2 weeks after the contentious board meeting, I received an unexpected call from Gerald Whitmore. "Mr. Jamison, I would like to propose a settlement," he said. "My client is prepared to drop all fines and withdraw their objection to your signal booster if you agree to relocate the antenna to a less visible location on your property." I was immediately suspicious. Define less visible. Perhaps on the back of your house instead of the roof. Or on a pole in your backyard. "That would not work," I explained. "The antenna needs to be elevated and pointed toward the cell tower to get adequate signal. Moving it to the back of the house or to ground level would defeat the entire purpose. What if you painted it to match your roof?" I paused. That was actually something I could potentially do. "Let me discuss this with my attorney and get back to you." I called Margaret and explained the proposed settlement. She was skeptical. "They are trying to save face," she said. "They know they are going to lose at trial, and they know Judge Morrison is likely to award attorney fees against them. But they want to be able to say that you agreed to modify your installation, so they do not look like they completely lost." "Would painting the antenna to match my roof be a problem?" I asked. "Not legally, no. It would not affect the function of the equipment or violate your FCC license. But you need to decide whether you want to give them anything at this point. You are winning, Connor. You could push for a complete victory and probably get it." I thought about it for a long time. Part of me wanted to push for total victory, to make the HOA completely back down with no concessions from me. But another part of me just wanted this to be over. The stress of the lawsuit had been affecting my sleep and my work, and I was tired of constantly thinking about it. "What if we propose a counter-settlement?" I said. "I will paint the antenna to match my roof, and in exchange, they drop all fines, withdraw all objections to my installation, agree not to take any enforcement action against any other resident who installs a similar licensed system, and they pay my attorney fees." Margaret was quiet for a moment. "That last part is going to be tough for them to swallow, but it is reasonable given that we would likely get fees anyway if we won at trial. Let me draft something and send it to Whitmore." The negotiations took another 3 weeks. The HOA board was willing to agree to most of our terms, but they balked at paying my attorney fees, which had now reached about $25,000. Margaret and I countered by offering to reduce the fee amount to $15,000 in exchange for a quick settlement. Finally, 6 months after Barbara Hendricks had first knocked on my door, we reached a settlement agreement. The HOA would drop all fines, withdraw all objections to my signal booster, agree not to enforce their covenants against licensed telecommunications equipment in the future, and pay $15,000 toward my attorney fees. I would paint my antenna to match my roof color within 30 days. The settlement was formally approved by Judge Morrison, who made a point of noting in his order that the FCC preemption doctrine was well established, and that HOAs should be careful about attempting to regulate federally licensed equipment. I painted my antenna the following weekend. It took about 3 hours and 2 cans of special weather-resistant paint that matched my roof shingles. When I was done, you really could not see the antenna from the street unless you knew exactly where to look, but the story did not end there. About a month after the settlement was finalized, I received a call from Patricia, my neighbor who had started the petition against Barbara. "You need to come to tonight's emergency HOA board meeting," she said urgently. "Something big is happening." I arrived at the clubhouse that evening to find it even more packed than the previous contentious meeting. The energy in the room was electric with anticipation. Thomas Irving, the board member who had been sympathetic to my position, called the meeting to order. Barbara was notably absent. "Thank you all for coming on short notice," Thomas began. "I want to inform you that Barbara Hendricks resigned as HOA president this afternoon, effective immediately." The room buzzed with conversation. Thomas waited for quiet before continuing. "Over the past several weeks, the board has been conducting an internal audit of HOA finances and decisions made over the past 2 years. What we discovered was deeply troubling." He went on to explain that Barbara had been using HOA funds inappropriately, including spending money on legal fees without proper board authorization, using HOA accounts to pay for personal expenses that she later claimed were community improvements, and accepting kickbacks from contractors who did work for the HOA. "The total amount of misappropriated funds appears to be around $75,000, Thomas said grimly. "We have referred this matter to the Maricopa County Attorney's Office for investigation." I sat in stunned silence. This was far bigger than I had imagined. "Additionally," Thomas continued, "we discovered that Miss Hendricks was personally responsible for the vandalism incident at Mr. Jamison's property. She hired someone to spray paint his lawn in an attempt to intimidate him. We have documentation of this payment in her personal financial records, which she was required to disclose as part of the board's audit." The room erupted in shocked conversation. Margaret, who had accompanied me to the meeting, leaned over and whispered, "This just became a criminal matter." Over the next several weeks, the situation unfolded in ways I could never have predicted. The county attorney's office opened an investigation into Barbara's conduct. They subpoenaed HOA records and interviewed board members and residents. It turned out that Barbara's financial misconduct was extensive and well documented. She had been essentially embezzling from the HOA for nearly 2 years. I was interviewed by investigators about the vandalism incident and the broader harassment I had experienced during the lawsuit. I provided copies of all the threatening letters I had received, the police reports from the spray painting incident, and documentation of the false FCC complaint that had been filed. 3 months after Barbara's resignation, she was formally charged with multiple felonies: embezzlement, fraud, filing a false report with a federal agency, and criminal trespass for the vandalism incident. The charges carried a potential sentence of up to 15 years in prison. Her criminal trial took place 9 months later. I was called to testify about the harassment and intimidation I had experienced and about the false FCC complaint. Margaret testified as an expert witness about the federal telecommunications law violations. The trial lasted 2 weeks. The prosecution presented overwhelming evidence of Barbara's financial crimes and her pattern of abusing her position as HOA president. Multiple residents testified about being threatened and bullied by Barbara over minor alleged violations. The jury deliberated for less than 6 hours before returning guilty verdicts on all counts. Judge Catherine Brennan, who presided over the criminal trial, sentenced Barbara to 5 years in state prison, followed by 5 years of probation. She was also ordered to pay full restitution to the HOA for the embezzled funds, plus additional restitution to me for my legal fees and the damage to my property. Miss Hendricks, you were given a position of trust within your community, and you abused that trust in multiple ways, Judge Brennan said during sentencing. You stole from your neighbors, you harassed and intimidated people who disagreed with you, and you weaponized bureaucratic processes to harm someone who was simply trying to do their job. Your actions warrant a significant period of incarceration. I attended the sentencing hearing, and I felt a complex mix of emotions watching Barbara be led away in handcuffs. Part of me felt vindicated. She had made my life miserable for months and had committed serious crimes. But part of me also felt sad that things had escalated to this point. If she had just accepted that federal law preempted her HOA rules, none of this would have happened. In the aftermath of Barbara's conviction, Pleasant View Estates underwent significant changes. The HOA board was restructured, with new elections bringing in several reform-minded residents. Patricia was elected as the new president, and she immediately set about implementing more transparent and reasonable policies. One of the first things the new board did was revise the community covenants to explicitly allow licensed telecommunications equipment, amateur radio installations, and signal boosters. They also implemented limits on the board's enforcement authority, requiring board votes before assessing fines over $100 and creating an appeals process for residents who disputed violations. The neighborhood's atmosphere changed dramatically. People were friendlier, less afraid of arbitrary enforcement actions, and more willing to actually live in their homes rather than constantly worry about HOA rules. As for me, my signal booster continued to work perfectly. My painted antenna remained nearly invisible on my roof, and I had excellent cell reception throughout my house. Several other neighbors installed similar systems after the covenant changes, and the overall cell service in the neighborhood improved as more people boosted their signals. I also became something of an informal expert on telecommunications law within the community. Neighbors would occasionally ask me questions about signal boosters, antenna installations, and FCC regulations. I was happy to help, sharing the knowledge I had gained through my ordeal. Margaret and I remained in contact, and she used my case as the basis for several articles she published about HOA overreach and FCC preemption. The case was cited in legal briefs in other jurisdictions where similar disputes arose, helping other homeowners fight back against unreasonable HOA restrictions on telecommunications equipment. About a year after Barbara's sentencing, I was sitting in my home office, working on a network optimization project for my employer, when my phone rang with an unknown number. I normally do not answer unknown calls, but something made me pick up this time. "Is this Connor Jamison?" A woman's voice asked. "Yes, who is calling?" "My name is Rebecca Sanderson, and I live in a planned community in Scottsdale. I am having a dispute with my HOA about a satellite dish I installed for internet access, and someone told me you might be able to help." They said you fought your HOA and won. I smiled, thinking about how far I had come from that first confrontational meeting with Barbara on my doorstep. I did, with the help of a very good attorney. Let me give you her contact information. I gave Rebecca Margaret's phone number and email, and I spent about 20 minutes explaining the basics of FCC preemption and the legal protections for telecommunications equipment. She was grateful and relieved to learn that she had rights and options. After I hung up, I looked out my window at the neighborhood. The sun was setting over the Arizona desert, painting the sky in brilliant shades of orange and purple. Kids were riding bikes in the street, neighbors were chatting on their porches, and everything felt peaceful. I thought about all the stress and frustration of the previous year, the angry letters, the lawsuit, the vandalism, and the eventual criminal prosecution. It had been one of the most difficult periods of my life, but it had also been strangely rewarding. I had stood up for my rights. I had fought back against unreasonable authority, and I had ultimately prevailed. More importantly, my stand had helped change an entire community for the better. The new HOA board was reasonable and fair. The oppressive atmosphere of constant rule enforcement was gone, and people actually seemed to enjoy living in Pleasantview Estates now. And my cell signal booster, the tiny piece of equipment that had started this whole saga, continued to work perfectly, giving me the reliable connectivity I needed to do my job. Every time I made a phone call or uploaded data to my company's servers, I was reminded of why I had fought so hard to keep it. Sometimes standing up for what is right, even in the face of intimidation and harassment, is worth it. Sometimes the federal government's protections for telecommunications equipment actually matter in real life. And sometimes, a determined person with a good attorney and the law on their side can defeat even the most stubborn HOA president. I turned back to my computer and continued working, grateful for my strong and stable cell signal, and for the community that had emerged from the chaos of the previous year. The antenna on my roof, barely visible beneath its coat of matching paint, continued to boost signals and keep me connected to the world in the end. That was all I had ever wanted. To be able to do my job, to have reliable communication, and to live in peace in my own home. Thanks to federal law, a good attorney, and my own willingness to fight back, I had achieved all of that and more. The nightmare was over, and everything had worked out better than I could have imagined.